Good morning. Good morning. Are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes.
And any additions or corrections or?
There's a lot of history we understand, Your Honor, but discussed it with counsel also restitution.
Speak up, I'm
I
sorry.
just want to make sure that the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but there's I mean, she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything?
I'm still continuing on my deferred. Because I'm actually supposed to start nursing.
I can't understand you.
I'm supposed to start nursing school.
When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, I
school
am.
with this type of criminal
Yes, ma'am.
history?
This is deferred. Yes, ma'am. Because I haven't been convicted of it. I'm a CNA now.
Where do you live now?
In Houston.
Okay, another issue that I see on here also is the restitution, because it shows 9,400, but then it also, that was from inside the bank, and then it shows 500 from an ATM and 100 from a cash app, totaling 10,000, not 9,400. Is that correct?
And that would have been added on, Your Honor, I think that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody.
I only went into it. I didn't have no access to the card.
Okay. So possibly the other person that was involved did that?
The only thing we knew about
That
was
was,
9,400 that was in the bank.
I wasn't aware of it, Your Honor, when we did it, when I got the PSIs, when I was notified, I was in the cash app. But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of 10,000, 94 from inside the bank, 500 from an ATM, and 100 from a cash app transaction. It doesn't matter if you did it or if the other person that you were with did it.
Yes, ma'am.
Y'all were working together. So you're both, and what's the other status of the,
I don't have the other status of another person, Your Honor. That's just one who has the charge. I'm not posting on there. But she's responsible.
yeah. So I mean, if there was another person, and you didn't give that
I
information,
don't
then
know.
that's, okay. Apparently the cops didn't either, so.
She went in the bank, she was one call. Size, whether or not she had a comfortable. The backside, not to my knowledge.
And hold on, so the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay, and so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim, however, we
So,
understand.
all right, so here's what I'm gonna do, Ms. Bogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm gonna find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. It has to be straight probation, and I realize that that's gonna potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so
I don't.
you do.
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together. So
I understand it all.
It's one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. Ma'am,
What?
this is not gonna help.
It don't matter. My life's going on.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back.
What?
I heard both.
Everybody heard it.
You're a bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either. You did.
He got me the plea.
He did he did a great job. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your
I gotta go to work, so I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. Let's see, can you... All right, I'm going to set your bond at $25,000. Go back with the bailiff. Good morning, Mr. Coleman.
Apologize.
That's okay. We were actually running a little early this morning, which is kind of rare.
I believe my claimant in this case, Mr. Mason, my caller may be here. I may have to call his name. If I could just call
Yeah, of course.
Mason, my caller.
Goodness. Just get some stuff moving.
Yeah, no.
All right, sir, you are Aaron Roberts, and this is 25 DCCR 0250, and Mr. Roberts was previously in court, entered a plea of guilty to the state jail felony offense of theft of property, and I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Defense has your,
State has, Judge.
Are there any additions or corrections?
none from defense.
Not from the state. Judge.
And so the agreement was for a 5-year probation, restitution in the amount of $33,204.98. There was a disagreement as to the type of probation, and that was going to be left up to the court. Is that correct?
Yes, sir.
It is your honor.
All right, let's go ahead and, Mr. Lane, you may proceed.
Your Honor, we're asking the court to defer all proceedings for 5 years and place Mr. Roberts on probation and to order the $33,000 in restitution. He was working for about 10 months. He worked for about a year with this company, if I'm not mistaken, but for about 10 months, there was no stealing at all. I believe he started in August 2023. He had a child who was born with respiratory problems. The insurance company was not paying everything, so back in June of 2024, the bills started rolling in, and then he started embezzling from the company, which he confessed to once confronted. He has pled guilty. He is remorseful about this, and today he was going to come as best he could with $2,000 as restitution to show good faith, but about a month ago, he lost his job. Apparently, they're watching YouTube. But he has now gotten another job in Winnie, getting paid $19 an hour. The state's probably going to argue that he's gotten a chance on deferred before in 2010. That was 17 years ago. He did successfully complete that. And I think with the felony conviction, as the court well knows, it's much harder to obtain employment. He has disclosed this case to his new job in Winnie. I'm told that they have not made a decision. He's working, but it could affect him. He does have the willingness and the ability to pay the $33,000 back. The court always will have the opportunity to, if he doesn't comply, to revoke his probation, given he has no juvenile history, no misdemeanor history. He gets his child, 2-year-old child, every weekend. It's type 2 diabetes, but he can do it. And I don't know if loss prevention with the company is actually paid in any insurance claim. And I know Mr. Roberts would like to address the court as well.
All right, go ahead, sir.
Like I said, I'm remote for what I've done, so I'm just trying to do all I can to pay back what I owe.
You know, on a 5-year probation, with my quick math, and I always joke about not being good at math, but that's $500 a month minimum to try to get this paid back. Mr. Coleman?
I'll be brief, Judge. Mr. Lane essentially made my argument for me. This is not this defendant's first run-in with the law. In fact, on a felony, a previous felony, he received 5 years deferred. He should have known, of all people with that deferred, having had that chance, that to engage in this activity, this felony activity, very well could result in him possibly going to prison, let alone being on a post-conviction straight probation, Judge. The victim here, the complainant from the company that he stole from is here if you want to hear directly from him how this negatively impacted that company. But Judge, people every day in everyday life have issues and financial issues that they deal with, and they don't resort to stealing more than $33,000 from their employer. I'm asking the court to put this defendant on a straight probation. Thank you, Judge.
Thank you, Mr. Coleman. And I appreciate the victim being here wherever they are.
Frank. Jamarian Martin.
You know, so Mr. Roberts, Mr. Coleman is correct. You did have an opportunity at a probation back in 2010. It looks like you were successful and you have stayed out of trouble since then. I really want this money as much as possible paid back. And my thought is probably the best way for that to happen is for a deferred probation so that you can hopefully try to keep some decent job, because it's true that a conviction is going to change all that. But so I do want you to understand though, well, let me do this. Here's what I'm going to do. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, but I'm not going to do that. I'm going to defer all proceedings and place you on probation for 5 years. I am not going to order a fine. I am going to order that you pay the restitution in the amount of $33,204.98. This is going to be a zero tolerance probation. You are going to be required to make some payment every single month towards this restitution. Even if it's not the full amount each month, there better be something being paid. What can happen is you can go this whole probation, and a lot of people think, well, I'm going to wait for my tax refund, or I'm going to wait on whatever it is, I'm going to sell something next year, and they think they're going to get caught up at the end. And what can happen is if you do that and you come back in front of me on a motion to revoke, and I find that you could have paid some of the restitution and you didn't, you could have done every other thing right on your probation and still go to prison in 5 years. So you need to pay as much as possible. Every tax refund you get will go towards this restitution. You'll be required to give probation all of that documentation so that you can pay as much as you can every single month, and then each year there's going to be that payment as well. You'll be required to do community service and follow all of the other rules and conditions of probation. Obviously, you know this is an excellent opportunity because this conviction's not on your record. The other side of that, though, any violation, you're back in here, you're convicted. Mr. Coleman will be reminding me what he argued today, and you'll likely be going to prison for up to 2 years. You understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck, sir. Thank you, Mr. Lane. Thank you, Mr. Lane. And Mr. Thibodeau, did you get someone hired?
I got a bunch of these that I'm trying to hire, but they're way out there on price. I mean, my circumstances may be better than later, but right now I can't afford the prices of these.
Who'd you talk to?
And
And these are okay if they're not on, so.
But I did get word not all that Mr. Wilkerson might be affordable, so I'll call him today.
And are you working?
I work for myself. I mean, work's been slim to none since November. I mean,
Well, maybe you need to get another job other than working for yourself if there's no work out there since November and we're in August, September.
We're working, so my house goes $1,600 a month. I mean,
I understand, but if work's been slow since last November and we're almost in November again,
well, I work, but I mean, it's just slow.
okay, then go find something else to do. Okay, I appreciate that you did what I asked you. I'm gonna give you 30 more days. I want you to try, see if you can get some more work, find another job, bring me that information when you come back, and then we'll see, at that point, what your options are, okay?
Sounds good.
All right, step in front of the clerk, please.
Good morning, Judge.
Good morning, sir. You're Daryl Albritton?
Yes, ma'am.
And Mr. Albritton, did you get someone hired?
Yeah, I talked to William Marcus Wilkerson face to face out of all the rest of them.
Uh-huh.
I'm gonna choose him.
You're gonna be able to hire him?
Yeah, he said he gonna look over it a little more, he need a little more time to look over it.
Okay.
I'm gonna choose him.
But you think you'll be able to afford him?
Yeah.
Okay.
Yeah, my budget, yeah.
Okay, so I'm gonna give you one more reset to get Mr. Wilkerson hired.
Yes, ma'am.
Once you get that done, bring the reset notice that you get to him. He'll tell you what to do. If for some reason that's not gonna work out with Mr. Wilkerson, then make sure you talk to at least 3 other attorneys. You can tell they all have different charges and payment plans and things like that. Bring me those names and then we'll discuss your options, okay? All right, if you step in front of the clerk, please. Edward Frank, good morning. Are you Edward Frank? And Mr. Frank, were you able to get someone hired?
I talked to Mr. Macon and Mason Adams and, Mr. Macon on 6,500. I forgot, Mr. Adams, I think he said give me 3,000, and then I talked to the family, something like that.
Mm-hmm.
Yeah, I talked to him, but I'm trying to see how they go for it.
Are you working, Mr. Frank?
Yes, ma'am, I'm Bechtel, and I'm waiting on Bechtel to call me back now. I'm working with Bechtel and McDermott.
Okay. So are you laid off right now or you're working?
Later on.
You are laid off right now? Okay. So what I'm gonna do, Mr. Frank, is have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure you fill it out accurately and completely. Don't just leave it all blank. Fill it out, and then I'll take a look at it in a few minutes. If you step in front of the clerk, she'll give you that information.
You need these cards that I...
No, sir. Thank you for bringing them, though.
Thank you.
And are you Tiffany Elair? Yes, ma'am. And Ms. Elair, this is your initial appearance and cause number 25, DCCR 1002. You're charged with a state jail felony offense of unauthorized use of a vehicle, and that's from June 3rd of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Right. So when you're in custody, we automatically give you a court-appointed attorney. But if you make bond, I expect you at least try to hire your own lawyer. So what I'll do is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset notice. Good morning, sir. You're Chris, is it Morrell or Morelli?
Morrell, actually.
Morrell.
Morrell, yes,
I was all wrong. All right, Mr. Morell, did you get someone hired?
No success. I've been to 4 different attorneys.
Who have you talked to?
I've talked to James Macon, Mel Shalander, and J.T. Haynes.
Okay.
And the 4th one was Miss Barrazo, I think. I don't call her and everything, but she was in court, so I didn't actually have
Gotcha.
contact with her.
Okay.
Yes.
And so are you working?
I'm working, yes, ma'am.
Where you work?
Monroe's Cleaners.
Okay. And so as far as being able to afford or saving up, are you trying to work towards that?
I'm working for it, but no success because I have an excessive amount of bills to pay, and I can't split the difference.
So what I'm going to do this morning is have you fill out some paperwork to see if you qualify for a court-appointed lawyer, since you did what I asked you to do.
Yes, ma'am.
Make sure you fill it out accurately and completely. You're going to swear under oath that it's all true and correct, and then I'll take a look at it.
Yes, ma'am.
If you step in front of the clerk, she'll give you that paperwork.
Thank you.
Yes, sir. Good morning. You're Michaela Mercantile? And Ms. Mercantile, were you able to get someone hired?
No, because I also couldn't find a job. I put in like 20-something applications.
applications, I went to a few job interviews.
Okay,
I have another job interview today, I leave here.
okay. So what I'm gonna do this morning, thank you for at least trying to do what I've asked you to do. I'm gonna have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're gonna swear under oath that it's all true and correct, okay? If you'll step in front of the clerk, she'll give you that information. Good morning, you're Veronica Randall. And Ms. Randall, were you able to get an attorney hired? I'm sorry?
They kind of real expensive, but I talked to Silver, Brian, and Rain, and I was working with them and see if I can come up with some of the money.
Mm-hmm.
And, you know, when I get my check and stuff, and some Wilkinson also.
Okay. And are you working?
No, I get disability.
You do? So how much do you get a month?
I get like $9.50.
All right, so you do qualify for a court-appointed lawyer. Do you want to take advantage of that, or do you want some time to try to hire your own?
Can I take advantage of that?
No, and so we got appointed and then she wanted out apparently. On it, the procedural.
Yeah, I do see that. Let me look at this.
I don't remember that was back in May, she did.
There was a did he withdraw? Let's see. Oh, that was just the, okay. So let's do this. We appointed, let's just go ahead and put it back on it.
Yes, ma'am.
Yeah, all right. So if you'll step in front of the clerk, we'll put Mr. Vasquez, we'll leave him on your case, okay? She'll give you his information and let you know when to contact him. Step in front of the clerk, please.
Good morning, Your Honor.
Good morning, you're Dalton Frege?
Yes, ma'am.
And Mr. Frege, were you able to get someone hired?
I was not.
Okay, who'd you talk to?
Talked to Crenshaw Law Firm, Schwender Law Firm, Rothman Matthews, Bill Williams,
Speak up, please.
Rothman Matthews, Bill Williams, Butler Law, Inc., and Law Office at Sidney's College.
Okay, and so are you working?
Yes.
And so where are you on being able to get someone hired, do you think?
I'm paycheck to paycheck with this job. I'm trying to get a raise, but it's not looking well till the end of the year.
Okay, where do you work?
Martin Brothers.
Okay. I don't know based on that if you will qualify, but I am going to allow you to fill out some paperwork this morning to see if you qualify for a court-appointed lawyer since you did what I asked you to do. I need you to make sure you fill out that paperwork completely and correctly. Don't just leave it all blank or anything like that, and then I'll take a look at it. You are going to swear under oath that it's all true, okay? If you'll step in front of the clerk on the end there, she'll give you that paperwork.
Thank you.
So do you have the docket for the bond forfeitures?
Yeah.
Just doing great.
Did you go to
No, all the same areas. Good morning. Are you David Kalina?
Yes, ma'am.
And Mr. Kalina is charged with injury to a child, elderly, or disabled individual. And what is the announcement?
And I believe, I got an email from Ashley toward that, and she's, I sent her some stuff to bring to Mr. Knopf about a pretrial diversion.
Okay,
And she told me she likely wouldn't have
that
a
done by,
response today.
sure.
So,
Okay, so what I'll do is reset it a normal reset. It's about 30 days
That's
to
fine.
maybe get it in front of him.
Okay.
And then we'll see where y'all are at the next court date.
Sounds great.
Stay in touch with Mr. Cat. He'll let you know when you need to be back.
Yes, ma'am.
All right, you're free to go.
Thank you, Your Honor.
Thank you.
Good to see you.
You too, sir. Good morning. You are Precious Eaglin?
Yes, ma'am.
And let me get this pulled up correctly. All right, have you been getting that patch switched out like you're supposed to?
I didn't have the money, I just started a job, so I didn't have, the funds to get another one, but I just started a job, I get money Friday.
Okay,
I had got the first one.
have a seat in the jury box. Let's get you tested this morning.
Okay.
And then you've got Kevin Diaz, Mr. Rojas. Kevin Diaz, Anna DC Sanchez Diaz.
Say that.
It's okay.
Usually try to get him, I think it's one of these fleas concerned with transportation.
Okay, well, so this is gonna be to a lesser, okay, I'll make that notation on it as well. And it's transportation code, what's the code do you know the section by chance?
Charlie and I talked about it.
Do y'all have it written down?
I don't have it off the
Fleeing? Fleeing?
545.421C.
545.421C. I got it. Okay. All right, are you Kevin Sanchez Diaz? And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Sanchez Diaz, the state has elected to proceed on the lesser included offense. And what level is that?
It's a B, I believe.
Is it a B?
It's a B, Judge. It's my understanding.
Okay. The state's elected to proceed on the lesser included offense of a Class B misdemeanor of fleeing a police officer under Transportation Code 545.421C, and that's from March 5th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a, and I said fleeing, but it's eluding, actually.
In the DPS code, this is
Fleeing.
Both, Judge. It says
Both.
fleeing or eluding.
Okay. Okay. So it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Diaz is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 1 year. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have this conviction on your record. And at the end of the probation period, if you successfully complete it, the case will be dismissed. You'll never have this conviction. The other side of that is if you violate any condition of probation, you can be brought back into court. You could be found guilty and you could go to the Jefferson County Jail for up to 6 months. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, so you've waived your right to appeal. You need to have a seat here in the courtroom. The lady that's sitting at that desk right there is with probation. She's going to call you up when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you. Just a minute. Good morning. You're Christopher Pickens. Good morning, Ms. DeLage.
Good morning. Sorry, Judge.
That's okay. I've got Mr. Pickens here and Mr. Smith in cause numbers 24 DCCR 2275 and 2276. Mr. Pickens' cases are set for trial to begin with jury selection on Monday, September 29th. Yeah. And so I know, Ms. DeLage, you had mentioned to my clerk that you were going to file a motion for continuance, but we don't see that. Did you get that filed?
I did. I first received some kind of weird error that said the e-filing system couldn't process it, something I'd never seen before. So then I refiled it in the same envelope. That caused another error. And so then I refiled it again in a new envelope, and I don't have any results from that.
Okay. And what is the, I guess, just let us know, since you're here, what is the purpose or the reason for that motion?
I am on my way to a trial skills training in Austin and knew that I wouldn't be dressed and available.
No, but for trial's not until the 29th. So can you be ready?
Oh. Yes, I can be ready for the trial on the 29th. I just couldn't be there today.
Gotcha. All right. And has there been any other negotiations or anything like that? And so, Mr. Pickens, you still want to go forward with your trial, is that correct? All right, so what I'll do is number the cases tomorrow after the docket, and your attorney will get that trial order, and she'll let you know when you need to be back on the 29th. Yes, sir. Stay in touch with Ms. DeLage, and she'll, that way, if you're at the top of the list, you guys can get together and start, make sure you're prepared, okay? Thank you for zooming in, Ms. DeLage. And
No problem. Thank you, Judge.
Thank you. All right, you're free to go, sir. Good morning, you're Erica Messina. And Ms. Messina was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle. I've received the pre-sentence report. Has everyone had an opportunity to review that report? Are there any additions or corrections? All right, ma'am, I'm going to find that you entered your plea of guilty previously, freely and voluntarily. Find that you're mentally competent, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have this conviction on your record. And at the end of the probation period, if you're successful, the case will actually be dismissed. You'll never have a felony conviction. The other side to that is if you violate any condition of probation, you can be brought back into court, found guilty, so you would have the felony conviction, and sent to prison for anywhere in the range of punishment, which is between 2 years and up to 10 years. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. Thank you. And you've got Duma Turner, okay. All right, you're David Holland. Okay, so a couple things. First of all, this was the final reset with regard to what was going to take place on your case here. So what is the announcement?
Judge, we haven't, the money hasn't come in yet. What I asked Mr. Coleman a moment ago was that while he was in custody, if he should get the money in to pay it, I don't know how that would get conferred to me or to the court or anybody.
Where's the money supposed to be coming from, Mr. Holland?
I have it. I have it. Most of the money. It's on my friend's card. I was trying to get on last night and this morning, but he didn't answer me or nothing. And I didn't have time to go out to his house. So he lives in Bevel Oaks, and I was like,
It's on his card?
he has money in his bank. He's going to send it to me on my Cash App card. And that way I'd have it. But
okay, so here's well, I'm not going to reset it. Y'all need to take care of this in another way. It can be some type of probation where he pays it back.
I made an alternative recommendation.
Y'all need to get that paperwork done, or it's going to go on the trial docket. We're not waiting anymore.
This is a different version than what the defendant gave you the last time.
It is. No, we're going to do, it's going to get taken care of today. Y'all can get the paperwork done. Obviously, if there's money that gets paid early, then sometimes probations are terminated early, but the case is 1,600 days old. So
the state's alternative offers 2 years, the minimum of 2 years, given the defendant's criminal history. He's had a aggravated robbery probation that was revoked to looks like to 10 years, and a number of a third degree evading in 2003 that he did 7 years on, and the POCS, looks like he did a concurrent two years on that, Judge. Maybe some history out of the state of Ohio. I'm not inclined to offer probation, Judge.
oh, okay. But if he had all the money, it was going to be
A misdemeanor, Judge, and just a little time in misdemeanor in county jail.
and we've got this warrant now because you didn't go take care of that either this last week.
Because I worked all week and you guys not paying me till Wednesday, so I mean, there's nothing I could do. I didn't have any more money to give. I mean, I gave it all to my friend so he'd hold it for me so I wouldn't spend it. Because I hadn't got the money from the.
Okay, so here's the thing.
Bankruptcy.
Okay, it's obviously you know what the offer is. Y'all can take that offer. You can reject that offer and go to trial. But something's going to happen today.
I can't hear as well as I used to.
So the offer is, I'm not going to reset it again for the restitution. So it's either plea to whatever the offer is, plea open to the court, or do a plea bargain rejection, and I'll set it for trial. So have a seat over in the jury box, and y'all take care of whatever paperwork it is. I'll need paperwork for any of those. The way things are going this morning, I would have almost believed you. You're going to throw me off. All right, Ms. Eaglin, you tested negative. It is extremely important. That's a condition of your bond that you have that drug patch. So you need to make sure and do everything you can to get it, keep it every 2 weeks, get it changed. If you don't, it's a violation of your bond condition and you could end up back in court. You could end up in jail for violating that, okay? So it's very important. So let me get this pulled up. Ms. Eaglin, in cause number 25 DCCR 0317, you're charged with assault of a peace officer. And that is from January 14th of 2025, and that's a second-degree felony. What that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? Speak up, please.
Yes, ma'am.
Okay, and then in cause number 25, DCCR 0318, you're charged with aggravated assault with a deadly weapon from January 14th of 2025. And that also means if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand? In each of these cases, I have here on the computer a plea bargain rejection that you've signed with Mr. Rojas that shows that the district attorney's office has made offers if you wanted to enter pleas of guilty in your cases, actually in one case. So the offer is to plead guilty in the assault on a peace officer for a 7-year deferred probation with a dismissal in the aggravated assault case. You have every right to reject that offer and have your cases set for trial. I want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your cases set for trial? And Mr. Nichols, is there any reason to believe that the offer would change? So I want to make sure you understand also that after today, I will not accept this plea agreement. Once the case goes on the trial docket, you can either plead guilty to something different, open to me, or we're going to let a jury decide, okay? All right, so I'm going to place your cases on the trial docket. Ms. Eaglin, Mr. Rojas has been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him, and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you? All right, so Mr. Rojas, you are released. Ms. Eaglin, if you will just have a seat right over here in the courtroom, watch for the clerk to call you up. She's going to let you know who that attorney is today so that you can contact them and they'll begin preparation for trial. All right, thank you. Now, what you got? Just a new prescription. Good morning. Are you Jamarian Martin? Speak up, please. And will your client waive the formal reading of the indictment?
You are.
Mr. Martin, in cause number 25, DCCR 0196, you're charged with the state jail felony offense of burglary of a building, and that's from October 3rd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Are you pleading guilty freely and voluntarily?
Do you understand what's going on?
I do.
You do? Huh?
That's what I do. That's all.
All right, so are you entering your plea freely and voluntarily? Did anybody make you plead guilty? No? I can't, huh?
That's open freely voluntarily.
He said freely and voluntarily.
Okay. Has there been any issues, Mr. Parker?
There hadn't been, Judge. No.
Mr. Martin, if I test you this morning, you can have something in your system? You're not sure? Have a seat in the jury box. Let's find out. Good morning. You're Hillary Lawrence. And will your client waive the formal reading of the indictment?
Well, you are.
Ms. Lawrence, in cause number 25, DCCR 0296, you're charged with the state jail felony offense of theft of service, and that's from February 6th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the tablet some documents that have your signature on them. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? Bless you. And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would not be a fine, but there would be restitution, and that would be determined before sentencing. Is that correct? Y'all don't know the amount?
Yes, that's correct.
Okay. Is that your understanding of the agreement? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Lawrence is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Also, that'll give them time to figure out that restitution amount. When you're leaving the courtroom today, you need to stop and talk to probation, and she's at that desk right over there, okay? All right, we'll see you back at sentencing. Then you've got Mark Hebert. It's the sentencing, Mr. Parker. Good morning. You are Mark Hebert?
Yes, ma'am.
And Mr. Hebert was previously in court, entered a plea of guilty to driving while intoxicated, third or more. I've received that pre-sentence report. Has everyone had an opportunity to review the
We have,
report?
Your Honor.
Are there any additions or corrections?
None more of, Judge.
Not from the state, Judge, sorry.
Okay, that's right. And so, Mr. Hebert, I am going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 5 years in prison, but I'm going to probate that. You'll be on probation for 5 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. In addition, you are ordered to serve your 10 days upfront time in the Jefferson County Jail. Are you working?
Just been temporary, yes, ma'am.
Okay, so you could either go do your 10 days if you're ready to go do those today. I will allow you to do weekends if you're working.
Okay, I thought I already did 10 days.
No, no.
It doesn't count.
We had
Yeah.
talked before about doing it on weekends. I'm not sure, would you rather do it on weekends?
Yes, sir.
Okay, so what I am going to do is order that you serve those 10 days on weekends, starting this weekend, September the 19th. So you will be ordered to turn yourself in every Friday at 6 o'clock to the Jefferson County Jail. You'll stay the weekend, they'll let you out, and you'll keep doing that each weekend until you serve that 10 days.
Okay.
It's very important that you're on time to the jail and that you also not show up obviously under the influence of anything, because that would obviously be a violation of your probation. So if you do everything you're supposed to while you are on this probation, this is an excellent opportunity because you will be able to serve that 5-year sentence while you're out on probation. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you'll be facing that 5-year sentence that you've already agreed to. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal.
Would the court, excuse me, consider either JCDI or drug catch? I don't know if the interlock
It's
is
probably,
necessarily
can I see that
appropriate. It was
back? I'm
in the-
sorry.
it
What's
was-
this?
No.
Oh,
It may
I'm
already be
sorry.
in the orders. Just my concern is it being a drug issue versus alcohol.
Yes, JCDI is in there. Okay, so part of the conditions of your probation will be that you enter and successfully complete the JCDI program. And so that is an outpatient treatment program. It is very important that you go to every meeting, you not test positive for anything. I think in addition, I don't know that I'm required to, the interlock is required by law unless I make a good finding otherwise. If,
I don't think it would hurt anything. I just wanted to bring that to the court's attention.
no, but I'm thinking I'd much rather probably a drug patch. That's probably gonna be part of JCDI anyway, but it's gonna be part of the probation for
If
sure.
there's any medication you're on prescribed by a doctor, you need to make sure you
Give that to
talk to
probation.
probation about that. Because he has some health issues.
Are you driving?
Yes, ma'am.
Do you currently have the auto ignition interlock device on your vehicle? Okay, talk to probation, that'll probably remain, at least for some amount of time. By law, that is required that you have that on your vehicle, okay? All right, you can have not yet. I also handed you a admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right? If you'll just have a seat here in the courtroom, probation will call you up when she's ready to go over your paperwork. And then you've got a Jasmine Dempsey. That's okay. All right, you're Jasmine Dempsey. And will your client waive the formal reading of the indictment?
Yes, ma'am.
Ms. Dempsey, in cause number 25, DCCR 0315, you're charged with a state jail felony offense of theft of service, and that's from December 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred adjudicated probation. There would not be a fine, but there would be restitution ordered in the amount of $967. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? I have to ask everyone. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Dempsey is not competent?
There you are.
And since we have the restitution, is there any issues?
Yeah, we waive.
All right, so what I'm going to do, Ms. Dempsey, is waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to defer all proceedings in accordance with your agreement, place you on probation for 2 years. You are ordered to pay is it $967?
Yes.
The $967 in restitution, and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you successfully complete that probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you would go to the state jail prison for anywhere between 6 months and up to 2 years. Do you understand? It's very important that you make monthly payments on that restitution amount. Some people think they're going to wait for some money to come in, or they're going to wait till the end of your probation. The quicker you get everything taken care of on your probation, you can even potentially get off early, okay? All right, have a seat in the courtroom. The lady that's at that desk right there, she's with probation. She's going to call you up when she's ready to go over your paperwork. When's the last time you smoked marijuana? Tell the truth. Because what's going to happen is I'm going to get amounts, the levels, right? So tell me the truth. When's the last time you smoked? That's the truth? Have you done anything else? Speak up. Promethazine? When's the last time you did that?
What is that?
Cough syrup. Anything else with that?
Judges, obviously, up to the court's discretion, but we're definitely going to reserve the right to dismiss the ISF, properly substance abuse track.
How old are you? 19? All right, so I guess what I would rather do, I want to go ahead and get the process going if he's got a plea agreement. But I think based on his age and the nature of the type of drugs he's using, I am going to raise that bond. We'll get the pre-sentence report done, see if there's any issues with regard to substance abuse, and if there's any upfront that, treatment that I find necessary at that point. So let's go ahead and go through the plea. And will he waive the formal reading?
He
I
will,
know we
Judge.
started it, but
He's already
we're gonna go
pled
back.
guilty. He said freely and voluntarily, and that's about where you left off.
All right, and so did you plead guilty to this offense because you actually did what they charged you with? You didn't? You didn't do what they charged you with? Look at me and pay attention, all right? Okay? Everything's gonna be okay, but you're young, and if you're gonna be successful on any kind of probation in life, you're gonna get some help early on right now so that you don't end up with a felony conviction, okay? But I need you to pay attention to my questions and listen very carefully and answer them. So, you're charged with burglary of a building. The question I asked is, did you plead guilty because you actually did that? Okay. I have here on the computer some documents that have your signature on them. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? Just pay attention to me right now. Do you understand the papers that you signed on the computer? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I go along with this agreement, you can't change your mind later. Do you understand? And it looks like the agreement's for a 4-year deferred probation, that there would be restitution ordered, which means you would have to pay back some money for any damage or whatever you stole, and they'll figure that out before sentencing. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number
No
one.
objection.
It's admitted. Is there any evidence that Mr. Martin is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so we can get a pre-sentence report done. If possible, I'd like to get some type of substance abuse evaluation done and any recommendations, as well as we'll get that restitution figured out, and then we'll come back later for sentencing. Based on the nature of the plea, based on your age and the fact that you tested positive for THC and admitted to using promethazine, I am going to raise your bond in your case to $100,000. If you make that bond, a condition of it is that you have a drug patch on at all times. So probation's going to come out to the jail, talk to you. We're going to figure out what all you need, and then we'll get you hopefully started in on this probation where you can be successful. All right? Go back with the bailiff. Thank you.
Sitting in the Beaumont Municipal Court waiting for his name to be called. So
Oh,
I
wrong.
apologize for that.
Yep, a lot more serious than that over there today. Mr. Hoffpower, this is yours. I'll recall the bond forfeiture. And this is cause number 24, DCCR 1998. Mr. Turner's charged with criminal mischief. And what is the announcement?
Judge, we're just asking for more time to review evidence. We haven't had a chance to do that yet.
Okay. And any issues?
No, Your Honor.
All right, so I'll just do a normal reset. Make sure you stay in touch with Mr. Galmore so you can go visit with him before that next court date. We'll see if we can get an announcement. All right. Thank you.
As well as Ms. Lopez here. She may come up, I think the court might need to admonish both of these individuals per my conversation with Ms. Lopez.
Okay.
If you've gotten to the point where you're frustrated, Ms. Lopez, you know there's an issue.
So are we going to go through the motion? Or what's?
Yes, please, Your Honor.
So let's do that first. Good morning, Ms. Lopez.
Morning.
And sir, you're Brandon Bell?
Yes, ma'am.
The best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay. And will he waive the formal reading of the motion?
So I,
Give me just a second to get that pulled up. Mr. Bell, in cause number 24, DCCR 1008, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation April 21st of 2025 for the second-degree felony offense of aggravated assault with a deadly weapon. That was a 5-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you failed to immediately report to the community supervision officer your contact information. And is that true or not true?
I failed to.
True or not?
It's just true or not true. You can explain later. So did you give them your contact information or not?
Yes, ma'am.
You did give it to them?
Yes, ma'am.
Okay, so that's not true. Count 2 alleges that you provided a urine sample May 29th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 3 alleges that you provided a urine sample July 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 4 alleges that you were at a location other than your residence at approximately 3:10 a.m. and 4:55 a.m. on July 10th of 2025 in violation of probation. Is that true or not true?
True.
Count 5 alleges that you failed to provide all records and documents required by the supervision officer within 30 days of their instruction. Is that true or not true?
Not true.
Count 6 alleges that you failed to provide verification of entering and successfully completing the BIP program, the Battering Intervention and Prevention Program. Is that true or not true? Have you done the BIP program?
No, ma'am.
Okay. So that would be true that you haven't successfully completed it, right?
Yes, ma'am.
Okay. Count 7 alleges that you failed to, that
I
you
think
fa-
you should say not in there, Judge, I'm sorry. You failed to not have any communication.
state wish to amend that to say not on number 7.
Yes, Judge.
Failed to not, any objection?
Objection.
So 7, hold on, let me make that. I'm printing it because it'll be easier for me. All right, so 7 says that you failed to not have all communication with the victim regarding your child through an approved third party by repeatedly appearing at the victim's house to, quote, see your children. Is that true or not true?
True.
Count 8 alleges that you admitted to the adulteration of your urine analysis on June 30th of 2025, and is that true or not true?
True.
You understand adulteration means? And the court could explain adult, I don't think he.
I mean, did you show up to probation and do either a fake urine sample or have some type of, what was it,
He admitted to drinking something that made his urine negative.
gotcha. So did you do that?
No.
You didn't? You just admitted it, but you didn't really do it?
Did you say it, or did you say that, or not? That you admitted to drinking
That, so
something?
it says you admitted to the adulteration of your urine analysis, that which means you told your probation officer that you did something to make your urine analysis negative. Is that true or not true?
Well, any piss test I
Urine
had.
test.
Any
Urine,
any
listen.
urine test I failed with.
Listen to my question. I don't care about any of that.
Yes, ma'am.
Did you admit to your probation officer
Not that I
that
know
you,
of.
did you admit to your probation officer that you drank something or took something that would make your urine clean?
Not that I know of.
Okay.
Let's say not true.
Count 10, let's see, actually count 9. Hold on, I'm out of 5, 6, 7, 8. What I missed here? Count 9, so this goes over here, alleges that you had contact with the victim of the offense, either in person, by telephone, via mail, or through a third party several times after being put on probation in violation of your order. Is that true or not true?
You say it again?
Have you had contact with the victim of the offense?
True.
And then count 10 alleges you are behind in your court-assessed fees as of July 17th, 2025 in the amount of $337. And is that true or not true?
True.
Did you enter your pleas of true to counts 2, 3, 4, 6, 7, 9, and 10 freely and voluntarily?
Yes, ma'am.
And because those counts are actually true.
Yes, ma'am.
So we've got, I'm going to find those counts true. Ms. Lopez is here. Let me look back at something real quick.
David? David?
When was the last drug test?
My last drug tested him on the 18th of August.
And it was negative?
It was negative.
And has there been any follow-up or treatment with spinal top?
You mean mental health or
Mhm.
drug treatment? Mental health, yes.
Okay.
Yes.
Weaver?
Oh wait, Your Honor, I apologize. August 18th was his last drug test and he tested positive for THC. He has since been drug tested again in September and it was negative. I gave you the wrong date there. I apologize. And I think the concern, if Ms. Lopez can kind of go into a little bit more detail about our conversation, is that he may be using synthetic, which doesn't show on the tests at probation. And there's obviously an issue with the no contact, which is why I have the complainant here. I don't think either one of them are adhering to that.
So last known contact that you know of that's not in here, has there been any?
I was called by the complainant on Thursday of last week and she admitted that they had been seeing each other that day. And she was angry but it's very inconsistent whether she wants to be around him or not. Some days I get calls.
Well, but I told you,
You come back in front of you.
Just be quiet, listen.
I told you you can't have contact.
Yes, ma'am.
And you're the one that can go to jail.
Yes, ma'am.
Okay, based on all of these allegations, I realized that I reinstated a bond and we had a hearing, it looks like, where I ordered some spinal top, but it sounds like this is not going in a safe direction at this point for anyone. At this point, I'm going to find that it is in the best interest of our community, best interest of the victim, and based on all of the factors in 15.17 and the fact that you're on probation for an aggravated assault with a deadly weapon, I am going to make this, at this point, a no bond. You will go back with the bailiff. I'll reset your case for an updated pre-sentence report. We can have any other testimony at that time with regard to the other allegations that are still pending. If you have any witnesses, then.
Since she's here, do you want to elicit testimony from the victim or not? She is
Judge,
here.
what my preference would be, may she come up to be addressed by the court?
Yeah.
Ms. Bell?
All right, so you are Daryl Spencer?
Yes, ma'am.
And Mr. Spencer has 4 cases, 24 DCCR 1863 charged with possession of marijuana, 25 DCCR 1149 charged with evading arrest or detention with the use of a vehicle, 25 DCCR 1150 charged with unlawful possession of a firearm by a felon, and then 24 DCCR 0841 also charged with evading arrest or detention with the use of a vehicle. And the state has filed motions in those 2 newer cases, cause numbers 25 DCCR 1149 and 1150, to raise the bond in those, or increase the bond. It looks like the current bond in each of those cases is $15,000. The bonds on those 2 previous cases, one was $7,500 and one was $25,000. And Ms. Malfino, you may proceed.
Judge, based on the fact that Mr. Spencer was out on bond, bless you, and then committed at least 2 additional felony offenses, we would ask, just based on the totality of the circumstances, the nature of the offenses themselves, the court raised all of those bonds and place him back in custody. And I will provide discovery to Mr. Kimler on the 2 new cases. He indicates today that he's going to be hired on those, but
I have you on all of them, right?
Yeah, I'm on all of them.
okay, I'll make sure.
If everyone will give me just a minute, I am going to take judicial notice of the court's files and all of the cases, which include the probable cause affidavit in those 2, well, all of them. Give me just a second to.
Just to be clear, the offense dates on the 2 new offenses are after the other 2 offenses, is that right?
Yeah, so the offense dates on the 2 We've got the possession of marijuana, offense date of February 15th of 2024, and the evading arrest or detention from March 2nd of 2024. And then we've got two new cases, one from June 14th of 2025, the evading arrest or detention with the use of a vehicle, and then June 15th, the unlawful possession of a firearm by a felon of this year. So give me just a second to review all of this, and then I'll let you. Sorry, I should have had these done already. Got one more, I'm coming, I think. All right, so let's see. On the two older cases, it looks like bond was made May 24th of 2024. So he was definitely out on bond on those when the two new. I should have one more.
Additionally, Judge, he has been before this court before in 2017, as well as next door and midterm.
So we've got, here's the,
We're gonna just go with the Class A amount. Yeah, it's gonna drag it. So this might be less than 750. Look, less than 750. Yeah, that should get us to what, Class A or B?
Yes, that's enough.
Let's do A, that's what it is.
Thanks, honey.
all right, so the unlawful possession of a firearm by felon and that evading, same offense, or date, pretty much same. And then okay, I should have another one. I should have one. Is there not anything else I printed?
Two of them are the same.
I know. I should have three. These two are the same, but I should have this one and another one. I
That's
thought
the three printed.
okay, hold on.
Yeah.
All right.
I think I filed them in both cases.
You did. I'm just trying to find the
The same
PCs
PC.
from the, I'm trying to look at the underlying PCs as well. So give me just a second to pull up which one is, what am I trying to
Well, it'd be
find?
the same, probably the same PC for each case.
Evading 0841. I didn't just print this one.
And two of them look just the same, but there's still stuff in it. And it's out.
Okay, maybe that's it. Why did it do two? What's happening? Okay. So you said he's previously been in other courts. What other, do you have convictions?
I do, Judge, I do have a conviction in this court from May of 2017, 9 months in the state jail for engaging in organized criminal activity. Also, it appears that in 2017, he was also in drug court for third-degree possession. It looks like he received probation on that case. There was a knock on that, so I don't want to misrepresent that. He did get 3 years TDC on that, Judge, on revocation, and then in CDC back in 2023, he was given a lesser included Class A deadly conduct, where he served 1 year in jail.
Mr. Kimler?
Well, Your Honor, I'm not prepared to litigate the merits of the two new cases without compromising defense. I suppose the court will have to stand on the PCs. I know that he's employed, is that correct, Your Honor? He's working on the court, yes, sir. Longshoreman, and is endeavoring to maintain a law-abiding lifestyle. I believe he could pass a drug test in lieu of an increased bond if the court is inclined to take some sort of remedial measures. Regarding Mr. Spencer's conduct while on bond for the previous two cases, I would suggest a GPS device in lieu of increased bond.
I don't see how a GPS is going to help when you're out on bond, got 2 felony convictions, a state jail and a TDC conviction. You're out on bond for a felony possession of marijuana and an evading arrest, and there's an additional arrest for an evading and an unlawful possession of a firearm by a felon. I'm going to, based on the criminal history, based on the nature of the underlying offenses, and all of the factors in 17.15, I am going to grant the state's motion to increase bond in cause numbers 251149 and 251150. I'm going to raise the bond in each of those cases to $100,000. Condition of those bonds, if made, are that Mr. Spencer not be allowed to drive a vehicle, period, on bond, and that he wear a, I'm not worried about that necessarily. Obviously can't have a firearm, but no driving whatsoever. All right, you can go back with the bailiff, and I'll reset the case for an announcement, or the cases. If I don't do that now, I'll forget. And this is Mr. Coleman on Roland Guillory. Good morning, you're Roland Guillory? All right, this is 24 DCCR 1568, and
So we have an agreement except for one aspect that we
Okay.
wanted to ask the court about.
okay,
So the agreement is to plead him to a lesser included attempted endangering a child, misdemeanor, Class A misdemeanor, 2-year deferred probation, $500 fine, forfeit the weapon. He wants to have psych evaluation because he does have he has a diagnosis of bipolar. But then there was also no contact with the mother of his child and supervised visits with the child. So the case stems from his mother, meaning the child's grandmother, calling, stating that he made a statement saying he was going to harm himself and the child. So his mother calls the police. It is documented his mother was intoxicated at the time that she called the police, but so the police stop his vehicle. He lets them know he is licensed to carry. He had his gun in his holster. It was no belligerent scene, and so they removed the golden holster and took him into custody. It was, and so.
Just based on that, I think what I would like to do, a couple things. One, even though it's being pled down to a misdemeanor, get a PSI, which will
Okay.
give me more information that it can also have time to get the psychological evaluation done.
Okay.
And during that time, have supervised visits. And then all that may change, but I think to be on the safe side, just pending sentencing,
Okay.
have a no unsupervised time with the child. Are they still together?
No, this happened last year. So they co-parent. I talked to her last week. So she said she didn't want the no contact. So that was our issue. Because I talked to her and she was like, she doesn't agree with that because they co-parent well and she's in school. So he has the child while she's in school. But Mr. Coleman said he talked to her in June. And so she did tell me, she said, well, at the time they weren't on very good terms. So she might have told Mr. Coleman she didn't want. But now she said they are on good terms. And so that was our issue, you know.
I've got notes in my file contradictory. I'm not doubting what
She
Ms.
said,
Holmes'
yeah.
version is today, as we stand here today, but I have a different version based on my conversation back in August of 24.
Oh, that's a whole year
with the
ago.
complainant.
Okay, so the
And
August
she's
of
not the
24.
complainant. She had nothing to do with
She's
it.
not
Well,
the,
mother of the child.
Yeah. So she had nothing to do, like she wasn't on the scene,
Well,
she wasn't.
Is she
Since
here
we're
by
doing a lot of
No, she's
this-
not.
Since we're talking a lot about extraneous things, Judge, and what other people said and say, she did tell me back in August of 24 that the defendant has a history of being harassing and threatening with regard to her, so.
but you haven't heard anything since then?
No, ma'am.
And that was a year ago?
Yes, ma'am.
Can I say one thing, Judge?
Yeah.
I do get my son every other weekend since this incident has happened, so, and we haven't had any issues. I talk to my baby mother every day. My son actually started school this year, so that's.
But y'all aren't still in, you and the mom aren't in a
We are not
relationship?
together. We're more of like friends. We decided we couldn't be together.
I mean, the fact that it's been a year and they've been doing that, I feel like that's probably okay. So let's, but I do think even though, let's do a PSI though, but I'll allow things to continue as they have been. And then, have you been receiving any treatment for any diagnosis
I did
that
go
you?
to spinal tap and I did get prescribed some medicine. I got prescribed some sleeping medicine, some bipolar medicine, and antidepressant medication.
And are you taking all that regularly?
No, ma'am, not currently.
Well, that causes me concern. So,
I haven't been on it in more than 6 months.
why?
I'm having transportation issues getting back to spinal tap.
Okay. How do you get your child? And,
My baby mom will drop him off to my house.
okay, you're gonna have to go to, you're gonna, because of the nature of what you're saying under that happened and even though if she was under the influence, if there were some threats that had to do with that and some mental health issues, then at least and we can do as quick turnaround as possible on a PSI. I am going to have only supervised visits between now and then. You need to get back to spinal tap when you come back for sentencing. You need to show me that you are cooperating and doing everything and following any treatment that they say, because it's going to be a part of your probation now. So you need to figure out a way to get there. You need to figure out, they'll help you with medication, whatever it is. And I want to know what you're on, what you're taking, and that you are following through with everything so that I know that you are in a good place, so that your child's in a good place, because we don't need to go back to what happened. So for now, you're going to be supervised only. So if you have someone that can supervise, great. If not, you just might have a couple of weekends that you go without, but we'll do it as quickly as possible. So let's go ahead and go through the plea then.
Yeah, because your mom.
Do y'all didn't do paperwork already though?
I have it here.
Okay, yeah, I'll hold it while y'all get that
So
done.
what do
I'll
you want me
recall
to
it.
Because I didn't put as far as the agreed recommendation, him having no contact with his
You don't have to
child.
put it as an agreed recommendation. I'll order it.
No
if you-
contact?
Judge, what I intended with the state, I recognize for the purposes of child exchange, there has to be some type of working.
Oh, yeah, I'm not worried about the contact with her. That doesn't seem to be an issue. It doesn't sound like that was an issue in the underlying part, so I'm not gonna order no contact with her. I'm going to order supervise with the child, because it sounds like that is what the underlying offense had to do with, not her. So y'all can either agree to mark it off, or I'll do it when it comes through. If you want to argue for it, that's fine, Mr. Coleman, but no, I'll allow him to have contact. You can have phone conversations with your child. You can FaceTime between now and then. I just don't want any if there's a supervised, y'all can if you can go somewhere, go to McDonald's, meet her there, have breakfast or lunch or something. No unsupervised. So I'm not saying you can't see them, but you just have to have somebody appropriate supervising until I get some more information. Does that make sense? Okay, and it can be her. If y'all are getting along, it sounds like that's not an issue. But I would say it's not going to be at her house. I want y'all to be somewhere public. That's not a good idea. Okay, y'all go take care of that paperwork and I'll take care of it. Y'all.
Do I put as a condition, as a probation condition, supervise it, or?
No, because that's gonna be a bond condition.
Yeah.
I'll say it when y'all come back up.
Okay, so I won't write it in. Okay.
Yeah. Just have a seat. Yeah, sure. Y'all can go over that paperwork and then I'll recall it in just a minute.
This is the forfeiture.
Okay, I just didn't know if you want to hold on to it.
Yeah.
Okay.
I just sent it to you.
Good morning. You're Seneca McDaniels. And what is the announcement?
Judge, with the court's permission, based on the underlying facts of this case themselves, we have agreed to forfeiture of this weapon. He has brought payment already today. We just need to figure out who to make it out to, and he's going to plead down the hall hopefully in 2 weeks. We can get the county court through from his home.
So what I'll do is just a normal reset here. That should all hopefully be taken care of. If for some reason that's not taken care of before the court date here, make sure you show up when Ms. Holmes tells you to, okay? Okay, you're free to go. All right, and courts, do y'all have paperwork on the tablet over there?
Our tablet died, Your Honor.
Okay.
Sorry, I should have probably.
There's another one over here.
Can y'all?
Well, this.
You didn't log me out. Okay. Yeah, it's all there.
What is plea bargain on a Brian Mitchell still on my tab? What did I do on that?
Just to take a fingerprint. It's a rejection. It's something I filled it out.
Yeah, right. It's gonna be right.
You got your
That's the forfeiture and the discovery.
No, I'm not. I'm being honest. It's all.
Yes, ma'am. Class A. Okay, on Roland Guillory. Again, you're Roland Guillory. And will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Guillory, in cause number 24, DCCR 1568, the state is elected to proceed on the Class A misdemeanor lesser offense of attempted endangering a child from March 15th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year deferred adjudicated probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Part of this agreement also is to forfeit the weapon, which I've already signed that order, and also to have psychological evaluation and to follow all of the recommended treatment. Do you understand? And are you a U.S. citizen? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Guillory is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I am going to get a pre-sentence report done on this case. I am going to ask Kristen if this is something that you guys can kind of do in maybe 4 weeks instead of 6. But and then we'll come back for sentencing. A condition of bond between now and then, a couple of things that we've already talked about, but now that we're going through this, I'm going to make sure everybody's on the same page, is that you're not to have any unsupervised visits with your child. That's so you can still have them do whatever like we talked about, so that I can get the pre-sentence report and see what's going on. Also, you need to immediately get an appointment with Spindletop. Hopefully you will have time to go to that appointment before the next court date. Bring documentation of anything you've done, any medication they've prescribed and things like that. And then at that court date, depending on what all that shows, then we'll get back to, at some point, I'm sure fairly quickly, you having your son again. But I just want to make sure everything is on track and that you are in a good position as well as your son.
Yes, ma'am.
Okay? You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right over there, okay? All right, we'll see you back at sentencing.
Oh.
But I'm not even clicking it, and it's just moving.
Sometimes it just does click. Now grab it.
I can't see it over here still.
There you go.
Don't call me mom.
Wait. Okay. All right, you're Daniel Spencer Ibarro?
Yes, ma'am.
And Mr. Kimler, will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
And it looks like we're going on the entire, all of the,
This is second degree.
okay, so Mr. Ibarro, in cause number 24, DCCR 1722, you're charged with the state jail felony offense of theft with previous convictions. That's from April 28th of 2024. And the indictment alleges you were previously convicted of theft September 8th of 1999, January 5th of 2000, 2 cases on February 7th of 2007, September 27th of 2010, May 4th of 2011, and then the indictment.
Oh, I'm sorry.
I know, but he's trying to pay attention to me. The indictment further alleges that you were previously convicted of burglary of a vehicle, a third-degree felony, May 19th of 1986, in 2 cases. And then after those were final, you were convicted of delivery of marijuana, a third-degree felony, November 30th of 1987. Also, delivery of marijuana that same date, November 30th of 1987. And after all of those were final, you were convicted of prohibited substance in a correctional facility, a third-degree felony, July 31st of 1999. And after that was final, you were convicted of driving while intoxicated, a third-degree felony, January 5th of 2000. And after that was final, you were convicted of driving while intoxicated, third-degree felony, October 29th of 2009. And how do you plead to that charge?
And I'm guilty of all of them.
So you're guilty of the offense you're charged with, and are all those priors true?
Yes, ma'am.
And then in cause number 24, DCCR 2289, you're also charged with the state jail felony offense of theft with previous convictions. This is from September 28th of 2024. It alleges all of those same prior offenses. And how do you plead in that charge?
Guilty of everything, Your Honor.
Did you enter your pleas of guilty and true in each of these cases freely and voluntarily?
No, I did.
And because you're guilty, you did what they charged you
Yes,
with?
ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Kimler?
I did.
And do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow any agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am, I do.
And it looks like the agreement that you've reached is for a cap of 10 years. The way the allegations and the prior convictions make these for punishment purposes a second-degree felony. The agreement is to cap your punishment at 10 years. Leave it up to me. You have an absolute right to have a jury come in and determine 2 things. 1, if you're guilty or not, and then secondly, to leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do?
Yes, ma'am, it is.
State tenders number 1 in each case.
Without objection.
It's admitted in each case. And also, sir, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
I do.
And is there any evidence that Mr. Ibarra is not competent?
None of my knowledge, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases so that the probation department can do a pre-sentence report, and then we will come back at a later date for sentencing. Anything that you think is important for me to know, get that information to Mr. Kimler and the pre-sentence officer, and then when you come back, they will present it to me on your behalf. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there.
Thanks, John.
All right, we'll see y'all back at sentencing. Good morning. You are Brian Tipton, and will your client waive the formal reading of the indictment?
He does.
Mr. Tipton, in cause number 25 DCCR 0149, you're charged with a state jail felony offense of solicitation of prostitution from December 19th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with your attorney? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Tipton is not competent?
There is.
And is there any criminal history, any reason not to waive?
Judge, he has criminal history, it's older, but there is criminal history, so I think we need to do a PSI.
Okay. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right there. All right, we'll see y'all back at sentencing. Thank you. Oh, I need the discovery certification. Thank you. And if you'll make sure and get that attachment emailed to the clerk. Okay. Thank you. Good morning. Are you Cedric Fontenot? Speak up, please.
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Mr. Fontenot, in cause number 24 DCCR 1665, you're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? Speak up.
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon? And do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 3-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection, Your Honor.
It's admitted. Any evidence that Mr. Fontenot is not competent?
No, Your Honor.
And what about this one as far as history?
Judge, this phone only has traffic.
Okay, so any issues with waiving the pre-sentence report?
Yes, Your Honor.
All right, so Mr. Fontenot, I'm going to waive the pre-sentence report. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings, and place you on probation for 3 years. You're ordered to pay the $500 fine and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, if you successfully complete it, the case will be dismissed. You'll never have a felony conviction. The other side of that is if you violate any condition of probation, you could be brought back into court, you could be found guilty, which means you'd be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? Also, if you get on this probation, do everything you're supposed to up front, get it all taken care of. I sign early terminations from probation every single day. So if you do it, you don't have criminal history, I have no doubt that you'll be able to be successful. If you get community service, get everything taken care of, it's likely that you can get off before that 3 years as well, all right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation's gonna call you up to her desk to go over your paperwork when she's ready, and she's at that desk right over there, so be watching for her to call your name. Good luck to you, sir, thank you.
Thank you, Your Honor.
Non-cooperation, cooperation. Non-cooperation, which I believe is still the case. I don't know what.
Look this way.
What is, I don't
You
know the
look this way.
relationship between the two of them. Obviously, I'm concerned for that. It's my understanding through Ms. Lopez that they're continually together, and that in addition to Mr. Bell, she is also violating that no contact order by voluntarily engaging.
I think they got children together as well, is that right?
Well,
And
that's
they're
why.
pregnant now, is that right?
But that's why I made the specific rule that they go through a third party to transfer kids, to see
And
kids.
the problem is that the third party is his mother, which is, I've told him multiple times, cannot be.
Cannot be, okay.
It's not working.
You are pregnant with this child right now?
Yes, sir.
So here's the thing, I can't necessarily order you, you're not here in court on an offense. But he's going to jail today because y'all won't quit doing what I told him not to do. So it's that simple.
Can I say something? Whenever I did call the probation officer, technically he was already staying at the house. We both our names are on the house. He was already staying at the house. So when I went to the house, I just wanted him to leave because, me and the kids needed somewhere to go. And I called the probation officer on my own, but he was technically staying at the house already. I just wanted him to leave because me and the kids needed somewhere to go. And obviously we all couldn't be there.
Right.
But he haven't.
So did he not leave so that you and the kids could stay there and that's why you called?
Yes, ma'am.
Okay,
But
then
he's
it's,
been staying there.
all right, well, then you know what you have to do. You're the one
I
on,
got out the house and I waited on my ride before my ride came.
well, if you're staying at the house
I don't
and
stay
you're,
there anymore. I stay with my,
I'm resetting it for a sentencing hearing. If there's any testimony at that time, you can recall witnesses, and so we'll come back.
Your Honor, I would implore the court to admonish them that contact includes calls from the jail.
It
that they're
does.
not
Contact, communication. Contact doesn't just mean in person, all right? It means communication. So you can't call her from the jail. You can't talk to her, period.
Man, we have children together. We have 4 kids together. I'm going to have another child for him. How are we supposed to? How are we supposed to co-parent if we can't talk to each other?
Well, y'all can't co-parent. That's why we're here. Because he assaulted you. He's on probation for felony assault of you. So we're not co-parenting isn't where we're at right now. Right now, we're trying to keep you, that baby, and the rest of your children safe until I know he's following all the rules. He hasn't done the classes that he's supposed to have. He's using drugs. That's not safe for y'all. That's not co-parenting.
Man, we're going to have another baby.
I'm sorry. There's choices that both of y'all are making, and that's a choice that you're making to still be with somebody that assaulted you. You can go back, go. You're Brian Mitchell? And Mr. Mitchell, in 24 DCCR 0170 is charged with aggravated sexual assault of a child. Case set for trial to begin with jury selection on Monday, the 29th. And what is the announcement?
We're ready. Can I just have a second, because I thought it was next week.
Yeah, we're down next week. The DAs are all.
I had one over on the Orange Judge that, no, it wasn't that week, it's the week after.
You're good on the 29th?
Yes, Your Honor.
Okay, all right, so I do want to make sure that after today, there will be no plea agreements accepted. Your case is likely to be at the very top of the list. It's one of the older ones, and so is there any change with regard to negotiations or anything like that?
No, Your Honor.
Okay, we'll see you back on the 29th then. I'll number the cases tomorrow after docket, and make sure you stay in touch with Mr. Burbank. He'll know the exact trial trial order tomorrow after docket. Okay? Yes, thank you. Good morning. Are you Tate Daly?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Please vote.
Let's see, we're going on 179. Mr. Daly, in cause number 25 DCCR 0179, you're charged with the state jail felony offense of driving while intoxicated with a child under 15 from September 2nd of 2024. And how do you plead to that charge? Speak up.
Speak up.
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in state jail prison, but that would be probated. You'd be on probation for 5 years. You'd be ordered to pay a $1,000 fine, follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
In addition, as part of this plea, the state would dismiss cause number 25 DCCR 0180. Is that also your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Mr. Daly's not competent?
There's none, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right? Well, yes, sir.
And Your Honor, for the court's information and also for the record, the endangering case under cause number ending in 0180 is not only being dismissed as part of the plea in this case, but also because it is the underlying facts are the same as the DWI.
Okay, perfect. Thank you. I'll sign that dismissal. Looks like it's already come through. So just stop and talk to probation on your way out, okay?
Yes, ma'am.
Yeah, okay, thank you.
All right, we'll take a list.
All right, sir, you're Tejuan Mack,
Yes, ma'am.
and this is 24 DCCR 1046. Mr. Mack's charged with criminally negligent homicide, set for trial to begin with jury selection Monday, the 29th. And what is the announcement?
That's right.
State's ready, Judge.
All right, I do want to make sure that after today, y'all understand that I will not accept plea agreements. And it's likely to be pretty high up on the list, depending on the other cases. Mr. Mack, you want to go forward with your trial on that date, is that correct?
Yes, ma'am.
We
Okay.
requested a speedy trial.
Well, it's
I understand. I was
set in 2 weeks.
Well, I know, but as far as the trial order, we have requested this.
I understand. The other case, though, is a child case, which would take precedence if that one in fact goes, but this likely to be probably the first backup to that, potentially. So
So you
we'll
want
see
him-
what else I have.
I
You
think
want
there's
him-
Batiste on there, Judge. I think he may be in custody.
Oh, he is.
It's somewhat of an old.
It is actually. So here's the thing, I will number the cases tomorrow. Stay in touch with Mr. Kimler. He'll know tomorrow after my docket what the trial order is and when you need to be back. Okay? All right. And Terry Mahler, Mr. Kimler, do you need to visit for a minute?
No, I believe she has the restitution.
Well, not all of that, 1,000 of it.
Y'all go visit then. Let me know what's going on.
It's 2,500 left.
Go visit and I'll,
Okay, yes, Your Honor. Hang on. That's it.
Richard Robb, Mr. Kimler.
I did a refusal on that, Your Honor. I'm sorry, we're gonna reset that one. I'm sorry. That's the one we're gonna reset. She needs some time to look at that. Just gonna-
Mr. Robb, come on up, sir.
Put your hands up here.
Good morning, sir. You're Richard Robb.
Yes, ma'am.
And this is 24 DCCR 2170. You're charged with theft of property, and what is the announcement?
Your Honor, the state's offered felony deferred probation we've counted with misdemeanor. I think the prosecution wants to review the file.
If the court would just give me a week or two, Judge, to determine if the restitution, if the item was returned, obviously the restitution will not be there. That's what our issue was, and then I'll offer
All right.
misdemeanor lesser included.
We'll reset it about 2 weeks.
Thank you.
Stay in touch with Mr. Kimmler, all right? And your bondsman, they'll let you know when you need to be back. We don't do that.
Oh, yeah,
Just
okay,
stay.
go ahead and go.
Your Honor, Souls?
Yes, ma'am.
Mr. Souls, what made you think that wearing that kind of clothes or shorts to court would be appropriate?
I apologize, Your Honor. When I came this morning and I looked at the door, I never really paid attention to the door.
But even, how old are you?
I'm 38.
You're 38 years old. You've been in courts before.
Yes, ma'am.
Because you have felony convictions, right?
Yes, ma'am.
So have you ever been able, or it was okay to wear shorts in court?
Well, like my parents, Your Honor, khaki shoe, they allow us to wear shorts. And I was kind of rushing to get out here. So
That's interesting.
I packed my bag and I came to court. I apologize.
Okay, don't wear shorts again. That is not appropriate in here in felony court, do you understand?
Yes.
Or in any court in Jefferson County.
In Texas.
Yes, sir.
So, Mr. Souls, in cause number 25 DCCR 0252, you're charged with the third-degree felony offense of unlawful possession of a firearm by a felon from November 1st of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have a plea bargain rejection here on the tablet that has your signature on it with Mr. Kimmler's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a cap of 4 years, which means you would leave your punishment up to me. I couldn't give you more than 4 years. I could give you 4, I could give you less. It would depend on the information that was brought to me at a sentencing hearing. You have every right to reject that and let a jury decide. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. Do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get it set on the trial docket. You need to stay in touch with Mr. Kimmler and your bondsman. They will let you know when you need to be back and ready for trial. Okay, you're free to go. You are Daniel Yarborough?
Yes, ma'am.
And Mr. Yarborough, in 24 DCCR 1722 and 24 DCCR 2289, charged in each of those cases with theft of property. The cases are set for trial to begin with jury selection Monday, the 29th. And what is the announcement?
Your Honor, I'm ready. I do think Mr. Barbo has endeavored since our previous setting to go through rehab and has accomplished some things. I'm going to provide to Mr. Coleman that may perhaps change the plea offer, but I am ready for trial. But we do have additional stuff I was going to tell you in the prosecution.
Judge, this case, in all honesty, should not be in the trial. I am willing, if the court will put this case on recall, to take a look at what he's providing. I may make an alternative offer. Unfortunately, the file's not in my bucket. I need to get someone to bring it
I'll
down.
hold it while y'all take a look at all of that.
You want to say something?
Just-
I would love to.
Y'all,
Judge, I
hang
think
on.
this is inappropriate.
Yeah, not
Okay.
yet. Y'all visit.
You
This
can't
is
talk.
between y'all right now, okay?
Okay. He needs to hear that from you. I'll try to tell him.
Looks like he's got something. Thank you. All right, again, you are David Holland. And Mr. Boudreaux, will your client waive the formal reading of the indictment?
Yes, ma'am.
Hold on, just a moment.
Judge, while you're pulling that up, I'd like to state that I looked up this defendant's jail credit. It looks like he's already got 2 days jail credit to go toward his sentence in this part of his plea. And also, I have no reason, while it's under the sheriff's discretion to grant 2 for 1, I have no reason to doubt that he wouldn't get the 2 for 1 as customary there at the jail. But again, it's for the total up to the sheriff.
Right, okay. Thank you. Let me get this, so we're going on count 1, well,
Lesser
count
included.
1 and the lesser included.
Yes, ma'am. The state would abandon the additional counts, all but paragraph 1.
And in that count to the lesser included.
Yes, ma'am.
Thank you. Okay, Mr. Holland, in cause number 21-36992, The state is elected to proceed on count one only, and in that count to the lesser included offense of theft from October 6th of 2020. And how do you plead to that charge? Speak up, please. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Boudreaux? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And the agreement is for 30 days in the Jefferson County Jail, and you understand. And you'll get whatever credits you already have, and then what the jail does with regard to 2-for-1 or anything like that is up to them. And are you a U.S. citizen? And you're ready, and and you understand you'll be going into custody today, correct? Okay. State tenders number 1.
Yes, ma'am.
Any objection to states number 1?
No, ma'am.
It's admitted. Is there any evidence that Mr. Holland is not competent?
Yes, ma'am.
Is there any evidence that he's not competent?
No.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser included offense of a Class A misdemeanor theft. Sentence you in accordance with that agreement to 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. There you go, and then you can just go back with the bailiff. That's for him. And Mr. Coleman, would you mind helping out with that discovery certificate, the attachment?
I'll get it to his one.
That's for your client. That's his.
Give it to him.
Thank you, Judge.
Thank you, and thank you, Ms. Holmes.